I asked him why he was so interested in this investigation when he was not interested in all the other criminal investigations and cases we had pending in the office.
All right. And what was his response?
His response was, I don't know about the other cases, but I know about this one, and I'm concerned about corrupt law enforcement because of what's happened to me.
All right. Anything else you recall he said in that conversation on the 26th?
We discussed the fact that he had taken Nate Paul personally to the Travis County District Attorney's office.
Did you ask him, or did he volunteer that?
I told him I had learned that. By this time, I had heard that.
And what was his response?
His response is, well, I didn't request the investigation from them. They had a conflict, and they asked me if I wanted it, and I said yes.
All right. What else?
I told him there was no state basis for believing there was any state offense, and he kept bringing up Nate Paul and Michael Wynn's complaint that the agents hadn't left a copy of the search warrant at the residence or the office, allegedly. I don't know if that's true or not.
Is that something he wanted the Attorney General's office to investigate about?
Apparently he did, because he told me that the fact that I didn't think that was serious, which I didn't, and I explained to him why. That's a federal rule of criminal procedure. That's not even a misdemeanor statute. And that's something the magistrate can deal with very easily if it's true. But he said that was a red flag to him that indicated I was too biased in favor of law enforcement.
How was the tone of this conversation?
He was frustrated, and that was the most, it wasn't a hostile conversation, but it was a difficult conversation.
How did the conversation end?
I told him that I was trying to be a loyal subordinate and a friend, and I still considered myself a friend even up to that very day. And I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it. I explained all the practical investigation difficulties, that we shouldn't be trying to investigate the feds, and there were many things we couldn't investigate. We didn't have the power. We didn't have a way to get at those sealed search warrants. And if I'd called the U.S. Attorney's Office and said, can I see your file with the original search warrants, they'd have laughed and hung up the phone, and I would have understood why. All that was under privilege at the U.S. Attorney's Office. They had an active investigation of Mr. Paul.
So how did when the conversation was over, what was said between the two of you as you parted?
The way I left it was I made two recommendations, which he didn't object to and he didn't disagree with, but then I found out later he obviously didn't act on them. Number one, I said, stop Cammett from working and talk to Jeff Mateer and figure out how to pay his invoice, and don't let him work anymore. Number two, let's you and I meet with Jeff Mateer. I can explain some options we've got. I don't think they're great options. You may want to pursue them, but I think they're a risk to the office. One of those options was calling the United States Attorney's Office, talking to one of the supervisors, see if they would just assuage our curiosity and tell us if there were any changes between the return version of the search warrant and the issued version.
And what did he say?
He didn't say anything to that. He just said, well, I've got to go. I've got a dinner to attend. But he didn't agree or disagree.
Why did you not take any documents?
I didn't take any because I felt like we were making the initial report based on our eyewitness personal knowledge of what we believed at that point to be criminal behavior by the Attorney General.
And so when you went, did you take evidence with you?
I took my personal knowledge and the others took theirs.
All right. Is that evidence?
Absolutely. We were eyewitnesses.
So after all you've been doing differently, would you do anything differently?
No, sir. I'd do the same thing all over again because it was the right thing to do and the only thing we could do, other than stand by silently and let crimes be committed. The agency was being abused. The laws were being abused. The behavior and the conduct of the Attorney General of Texas was outrageous.
Object to the state offenses that are alleged here. It wasn't a crime to follow up on them, was it?
No, it wasn't a crime to follow up.
No, but Your testimony earlier was you hope to slow walk it.
Yes.
Did you tell Michael Wynn that?
No.
Did you tell Nate Paul that?
No.
Did you tell your boss Ken Paxton that?
No.
And in fact, between June 17 and July 6, 2020, you only talked to David Maxwell about it, right?
Between what dates?
June 17 and July 6 of 2020, you only talked to David Maxwell about it.
That's not correct.
That was your testimony on direct. Would you like to correct it?
I would, if I may.
Please.
I'm sure I talked to Jeff Mateer as well. In fact, we talked to Jeff Mateer when he handed us the referral on June the 18th, probably.
We may be talking past one another. You did no investigation between June 17 and July 6. True?
We didn't do any, no.
Didn't do any work. True?
That's true.
Okay. And on the last page, you wrote the notes, Ronnie Saban, TFO. That stands for Task Force Officer. Yes?
Yes.
State Securities Board. Yes?
Yes.
How did he get the name Ronnie Saban?
Well, I know that he met Ronnie Saban because he claimed that Ronnie Saban had been executing the search at his residence, and they spoke to each other.
So what you're saying is, I don't want to put words in your mouth, Nate Paul knew Ronnie Saban was involved with the search warrant because he met him during the execution of the search warrant, correct?
Yes, he had personal knowledge of Ronnie Saban because he met him during the search.
Not because Nate Paul got some secret document from someone else, true?
No, that's absolutely false, and you misstated my testimony.
Did you call anyone at the magistrate's office, a clerk, a deputy clerk, the magistrate himself? Yes or no?
No, I never called the federal magistrate or his staff.
Did you call Alan Bowie, perhaps?
No, I did not.
Did you call any of his deputies at the U.S. Attorney's Office?
I did not.
How hard would that have been to do?
It would have been problematic in my view.
It would have damaged your reputation and the office's reputation, potentially, true?
Not my reputation. I wasn't concerned about that. I was concerned about the reputation of the office and our work with the federal authorities in the state of Texas.
For you to call the feds, you would have worried that that would have harmed the reputation of the office.
Not to make a phone call, but to
Then
make
why didn't you do it?
Because a phone call about this seemed to be high risk to the functioning of the Office of the Attorney General when we needed to work with federal authorities or appear in federal court, which our attorneys did all the time.
That would have been high risk to make a phone call? You're going to tell these senators it was high risk for the Office of the Attorney General for you to pick up the phone and make a phone call, yes?
Not to make a phone call, no. But to make a phone call about this, yes.
Well, why didn't you do it?
The reason I didn't do it is because Nate Paul was claiming there was a grand conspiracy between a federal judge, 2 federal prosecutors, at least 2 state agencies represented as task force officers, and a number of FBI agents. Nate Paul filed a civil suit against 100 law enforcement agents in federal court in Austin over this. And I thought to call the U.S. Attorney's Office and say, we have any belief that career AUSAs would be altering search warrants is crazy, especially when they have an ongoing investigation that's privileged.
In any event, you didn't make the phone call.
I
true?
did not, for the reasons stated.
Yeah. On August 13th of 2020, you had absolutely no evidence, physical, documentary, eyewitness, or circumstantial, that Ken Paxton was being bribed by anyone, did you?
I disagree with your statement. I had circumstantial evidence.
Oh, you had circumstantial evidence?
Yes.
Well, at some point on August 13th, did you go to your boss, Ken Paxton, and say, Attorney General, I'm concerned. I have circumstantial evidence that you've taken a bribe. Did you do that?
Not on the 13th of August. I did it later.
You didn't do that because you knew you would get fired, right?
I said possible bribery. I didn't have evidence to confront him with, not at that time.
Oh, but you just told the ladies and gentlemen of the jury you had circumstantial evidence.
Yeah.
So did you confront him with the circumstantial evidence?
No, the circumstantial
Object
evidence.
now responsive to everything
Mr.
after
Kennedy,
no.
please be allowed to respond. I'm just
Sustain your objections.
Thank you. Mr. Penley, below that it says, if you can zoom back out, Mr. Arroyo, he's using OAG/playing KP. Did you tell your boss you thought that Nate Paul was playing him?
Not on August the 13th.
Why not on that day? You had his phone number, right?
I'm sorry?
You had Ken Paxton's phone number, right?
Yes, I did.
Why didn't you confront Ken Paxton with your circumstantial evidence of bribery and the idea that Nate Paul was playing him on August 13?
Because I was trying to find a way to convince him to listen to reason and get away from this investigation, which I thought was highly dangerous to him and harmful to the office and injurious to the respect for the law in the state of Texas.
But also because if you had done that, you should expect to get fired, don't you think?
I could have been, and I was concerned about getting fired ever since Ken Paxton did a 180 and turned against me in the August 12th meeting, all the way to the end.
Okay. So just to be clear for the ladies and gentlemen of the jury, your concerns about bribery did not arrive until you thought Ken Paxton might fire you, yes?
No, that's not correct.
On September 26, did you have any physical evidence, documentary evidence, eyewitness evidence, or circumstantial evidence that Ken Paxton had committed or been bribed by Nate Paul?
I had circumstantial evidence.
Anything else?
I had his behavior,
Anything else?
the campaign donation,
Anything else?
his absolute refusal to listen to common sense and reasoned legal positions. He wouldn't listen to anybody on the executive staff.
Anything else?
There's 4,000 pages filed in response to the summary judgment. There's stuff in there.
Did you have any of them?
I didn't have it on September 26th. I know about it today.